Hi, my name is Nilo Sanchez. I'm an attorney here in Tampa with the law office of Sanchez and Associates. I've been practicing in the Bay Area for 26 years. I practice predominantly in the area of matrimonial and family law. I'd like to talk to you today a little bit about divorce cases, in particular the distinctions between a contested case and an uncontested case. The information that I'm going to provide you here is very general, and should you have additional questions, please feel free to call our office to schedule a consultation. To begin with, to get a divorce in Florida, either you or your spouse would have to have been a resident continuously of the state of Florida for 6 months prior to the time that you filed your petition for dissolution of marriage. One of the most essential requirements to a divorce at the outset is to determine whether it's going to be a contested case or uncontested. A contested case usually starts by the filing of a petition for dissolution of marriage. It's filed with the court, a summons is issued, and then a service is done upon your spouse. Your spouse will have 20 days to file his or her response. They usually will file a counterpetition, and in the counterpetition they would state the relief that they are seeking from you, just as well as your petition would state the relief that you are seeking from your spouse. From the moment that you file, within 90 days, at least here in Hillsborough County, Florida, you will have a case management conference. This is a hearing that happens before the court in order for the court to determine whether the steps that need to be taken and the requirements are being met. In particular, whether a financial affidavit has been completed, whether your mandatory disclosure documents have been produced, and if there are children involved, whether or not you have taken your required parenting course. After the case management conference, usually there's a mediation. At this mediation, there's a third party that neither represents you nor the other party, and it's an effort and an attempt to try to come up with an amicable resolution. If an amicable resolution is had, then the case reverts to an uncontested case, and we schedule a final hearing before the court, and we have a very abbreviated final hearing. If the case does not settle, either you or your spouse can seek temporary relief from the court. The court recognizes that divorce cases are long in terms of time. From the beginning to the end, a substantial amount of time may elapse, and a party may need relief from the other party. You are permitted to have what's called a temporary relief hearing, wherein you can ask for temporary spousal support, temporary timesharing, temporary child support, as well as temporary attorney's fees and costs. Is usually what you see at these temporary hearings. After the temporary hearing, some additional discovery usually takes place, and it could take on many different forms. And ultimately, if the case does not settle, it goes before a judge who will hear evidence and testimony, and the judge will make a ruling. At that time, a final judgment, or shortly thereafter, a final judgment of dissolution of marriage is drafted, and the court signs it, and you are divorced. It is beneficial to parties to try and resolve their cases amicably, if at all possible. Family law judges are vested with enormous amounts of discretion. What a judge may do today, they may not do tomorrow. Given the fact that they have so much discretion, that is judges, it's important to try and resolve your case if you can amicably. So typically, an uncontested case, if it were to start off uncontested, usually means that the parties have had discussions and have reached a tentative agreement, but yet they lack the legal knowledge in terms of how to put the documents together. One party will meet an attorney and will discuss the terms of the agreement, and if requested, some due diligence can be performed in order to allow the attorney to provide comments as to the merits of the agreement. And what is put together is what's called a marital and property settlement agreement, which is a binding contract. If this document is signed by both parties, we file it with the court, and we have a very abbreviated final hearing, where a few questions are asked of you. Candidly, the attorney does most of the talking. After all the testimony is presented, if everything's in order, the judge will sign the final judgment of dissolution of marriage, and you would usually walk out of the courtroom divorced. Those are the distinctions in general. There's a lot more information that's involved in these cases, but I do find that it's helpful for parties to have a general understanding of the process of a divorce, and I'm hopeful that this information helped. If you have additional questions, please feel free to give us a call. Our office is located at 1006 North Armenia Avenue. Our telephone number is 813-879-4600. We'd love to talk to you. Thank you.